All right, great. So yes, as I said, welcome everybody to the second session for the Thursday day of IDRA's 2025 online conference. I already did a longer spiel at the beginning of the last session, so I'll do a much shorter one. Just say, we're hosted by the Indigent Defense Research Association. If you'd like to learn more about us, indigentdefenseresearch.org. That's where you can go. We have a newly launched research database that we're hoping to expand going forward. And you can go to indigentdefenseresearch.org/donate if you would like to donate to our cause. Other than that, I'm going to pass it over to the first set of presenters, Jonah and Neil.
Hi, everybody. Sorry, you got me in the middle of taking a sip of water.
I could tell I timed it perfectly. Yeah.
Great. Good to see everybody today. So we are going to talk today. I'm Jonah Siegel. I'm the research director at the Michigan Indigent Defense Commission. And I'm co-presenting today with Neil Weinberg, who is the research analyst also at the MIDC. And we are going to talk today about implementing an attorney workload standard, which we are kind of smack in the middle of right now. We're going to just walk through challenges, lessons learned, and next steps. I hope that this will be helpful to folks who are, either doing research on workload standards, who are in the midst of implementing workload standards in any capacity, who have not really started to think about it, but are curious about it. And then, I suspect that many of you are much further ahead of this than we are. And we would, just love any thoughts on on all of it, frankly, on the standard itself, on the research side of it, on the political side of it, whatever thoughts you have to share. We would really love to hear at the end. Please feel free to jump in at any time. I'm going to walk through parts of the presentation and then jump over to Neil, who is going to demo some Excel trackers that he created for local systems to track workloads, and then I'll wrap up at the end of the presentation. But please stop us at any time. I'm a big fan of stopping if you need clarification, and otherwise we'll do questions at the end. Okay, so here's the agenda we're going to walk through. First, I'll just give a brief history of reform in Michigan. I think that probably some of you on the call are familiar with what things have looked like in Michigan over time, and it's probably also new to many of you. So I'll just give a brief introduction of that, talk about Michigan's new attorney workload standard, what it looks like, discuss the parameters of the initial implementation, and then the tools for local systems. That's what I mentioned that Neil will be demoing, and then talk about challenges and next steps. So just first a little bit about the history of reform in Michigan for those of you who are new to what's been happening in our state, which is probably most of you. So just a little bit of background. Pre-2013, there were a series of lawsuits in Michigan, and then also a report that was called Race to the Bottom, written by the NLADA, and that highlighted basically what a disaster Michigan's indigent defense system was in Michigan. And anyway, these series of things led to the creation of an advisory commission by the governor. Through another series of work groups and commissions, eventually the Michigan Indigent Defense Commission was created. And our job as a commission is to create minimum standards, work with local systems to implement those standards, and then award state-funded grants to local system to fund the implementation of standards, and then to collect and compile data on everything that we're doing to ensure compliance. At the time that we were created, and when things really got moving, it was really Michigan and New York and Texas were really the only indigent defense commissions that looked the way that we looked at the time. And now so many more have been created, and it's been really fun to see that process. It took us a couple of years to get them and moving. Standards had to get written. All sorts of things needed to be sorted out. And then eventually in fiscal year 2019, so that's fall of 2018 for us, standards implementation started, and that was the first time that we started rolling out standards. To give you a sense of what our standards look like, so this is 2019 through the present. These are the 9 standards that have been rolled out so far. And they've been rolled out in pieces. So the first 4 were rolled out, and then the 5th was rolled out, etc. There was a deliberate decision on the part of commissioners to not roll all the standards out at once, even though they were essentially, the statute is very clear in what the standards need to be, not the specifics of them necessarily, but what they need to speak to. And there was an early decision not to roll everything out at once because they thought rolling it out in pieces would actually make it more successful. Who knows if that's true or not, but that's what it's looked like here. I'll just run through them if people are interested. So some of them are self-explanatory. Continuing education for attorneys. We were one of the very few states who did not require indigent defense attorneys to complete continuing education at the time. So now that is a requirement. Confidential meeting spaces and initial interviews. It was a regular occurrence, as I'm sure many of you are familiar with in your own states, that attorneys were meeting with clients in hallways, just all over jails, in and courthouses and spaces that were not confidential. The initial interview speaks to making sure that an attorney gets out to meet a client within 72 hours, 3 business days technically of appointment. Sometimes days and weeks were going on before a first contact was made. Experts and investigators used pretty sparingly before the MIDC came along. We all know how important that is. Counsel at first appearance, also one of the states that did not provide counsel at first appearance prior to the MIDC. Now that has changed. Independence from the judiciary. So the court no longer appoints attorneys in Michigan. It has been pulled, that function has been pulled out of the judiciary and put into the local funding unit. So that is separated now. Indigency, I have to say that word so often and still can't say it. And compensation. So how people are kind of declared indigent, and also what sorts of money they have to put towards representation. Attorney compensation, bringing salaries and hourly rates up to par. Attorney workloads, which is what we'll talk about today, and then attorney qualification and review. So we are in the middle of the last year of these new standards being implemented, and it's just the very last 2, workloads and qualification and review, that we are in the middle of right now in fiscal year 25. So like I said, we're smack in the middle of it. So the workload standards are standard 6. They were not implemented in order necessarily, so don't be confused about that, but it's called standard 6. That's how we all think about it here. And so here is some text from standard 6. I'll just let you read it. But the gist of what it gets at is that the mere presence of a lawyer at trial is not enough to satisfy the constitutional command. So it's not enough to say that you have an attorney there. There also needs to be other parameters around that. And specifically in this standard, that the public defense system has to ensure that defense counsel's workload is controlled to permit the rendering of quality representation. So again, as many of you are familiar with, attorneys drowning in caseloads. And so at the time that these were written, which I'm going to show a timeline next, but this was about 2015, 2016. At the time, there was no national workload study that's now come out and been so helpful, except going back to the 70s, the ACCD numbers of 150 felonies or 400 non-traffic misdemeanors per attorney per year. That's what was put into the standard at the time. And you can see in the second paragraph here, it says these workloads will be determined over time through special Michigan specific weighted caseload studies. So the standard did contemplate getting something more specific and more current in Michigan, but use those numbers as a placeholder. Again, so to show the timeline a little bit, so the MIDC Act in 2013, the development of Standard 6, it was like 2015 to 2017. We did end up bringing Rand in to do a workload study, and that was about 2017 to 2019. The commission took the numbers from the RAND study, revisited Standard 6, and then in 2020, 2021. And then standards were passed in this standard was passed in 2023 at the, same year that the National Workload Study also came out with their new numbers. Um, I think that ours had been passed kind of just before that, but that, it was happening in the same time frame. And then, like I said, implementation of Standard 6 this fiscal year, so FY25, which started in FY24. Um, and so, interestingly, we did do a workload study, a Michigan specific workload study. Uh, the numbers came back, not surprisingly, much lower than the 150 felonies and 400 non-traffic misdemeanors. Um, and actually even not as low as the new numbers that just came out in the national workload study. So, we know that these numbers of 150 felonies and 400 misdemeanors are too high. We know that. Um, and that's how the standard was passed, despite the RAND study being done. But interestingly, what the commission has done over time, and that's for political reasons, and financial reasons. When I spoke to the folks at Rand about it at the very beginning, before they had started, they said, I said, look, how do people use these numbers? What does that look like? Because this was still a little bit earlier on, before everybody was doing workload studies. And they said, look, these are ideal numbers. And we understand what the politics look like, and we understand what budgets look like. The reality is that, most of the time these numbers are not passed as is, but that they are, they provide guidance on maybe what would be true in an ideal system. And that's been the case here. When it was time to reconsider the numbers, the commission, what they were looking at is already having gone from the state contributing $0 to indigent defense in Michigan to over $200 million per year. And they knew that it was not realistic to push those numbers even further at the time. So, Standard 6 was passed as is, with the recognition that that needs to be revisited at some point. And that was kind of the only realistic way to push it through at the time. Um, I'll give you a sense of these were the final RAND numbers. If you want to see the recommendations, you can see again that they're much lower. If you think about 150 felonies per year, and here under the red arrow, you can see felonies, which are far more broken out in many more categories than, of course, just felonies and misdemeanors, ranging from 15 to 74, just as an example. So depending on what sort of felony they are. So again, we know what we're working with, and for Michigan, what we've moved forward with is still a huge leap than where we have been. And so this is how these are the final parameters of how the standard got passed. Like I said, 150 felonies or 400 non-traffic misdemeanors. With some exceptions, traffic misdemeanors, probation violations, and contempt cases counting as half of a non-traffic misdemeanor. So some recognition by the commission that those cases take far less time. Only adult criminal indigent work counts towards the maximum. So, this is a conversation that I know is happening in other systems as well, is what for public defenders who have a salary and are only taking indigent defense cases, it's pretty simple to calculate that. For attorneys who are on a roster somewhere, and that's many, many attorneys in Michigan and many systems, those attorneys might be doing other work besides indigent defense work, and they typically are. So how to count that? And the commission decided that in years 1 and 2, we were not going to count that at all, which is pretty controversial. Guidance on how to handle reassignments or co-counsel, and then systems that use house counsel or shift coverage models. And many of our systems cover arraignment in that way. In fact, probably most of them. Hours worked outside of an assignment have to count toward that limit in some way, right? And so, like, just as a quick example, if you think of somebody who can take 400 misdemeanors per year, and then they're working next to somebody in their office who can also take 400 misdemeanors, but they're working an 8-hour arraignment shift every Monday. You have to find some way to account for the fact that they are going to have fewer hours to take assignments than the person who's not taking an arraignment shift every Monday. And so we had to calculate that into the, kind of a proportional rate that, and Neil will show that a little bit when he goes through the trackers, how that is factoring in. So, right where we are, funding for Standard 6 started on October 1st last year. Systems have 180 days to come into compliance. So like I said, we're right in the middle of it. And reckoning with the round results. So what the commission has decided, the way it works here is that local systems come to us with a plan and a budget, and then we, go back and forth, reject it, approve it, whatnot. So, some systems came forward and said, look, we want to do better than this. So we saw the round numbers, and we don't want to stay at 150, 400. We want to be at, 75 and 200 or whatever. They all came with different numbers. And so the commission has supported those, has moved forward with those budgets and said, essentially the standard is a floor, and, you can go above that, recognizing these round numbers. And so what does tracking look like? So it's been pretty tricky here because we have decentralized delivery models. We are an oversight agency, but we do not, we are not tracking individual cases in any capacity. We have a mix of public defender offices and managed assigned counsel systems. There's a lack of standardized software, and in many places, especially managed assigned counsel systems, there's no software. And so, we do get information from systems on their caseloads every quarter, but that's not frequently enough to be tracking, kind of real-time workloads. And so we have been trying to work with some software vendors to improve their products to help, but again, the decentralization makes this pretty challenging. There are many caseload or many case management systems used throughout Michigan. So I'm gonna kick it over to Neil to just demonstrate some of the trackers that he created to help local systems track their caseloads. So I'm going to stop sharing my screen. Neil, do you want to go ahead?
All right, can everybody see? There should be looking at an Excel sheet. Does that work? Great. So we started kind of with the question of Jonah. I don't know if Jonah mentioned it exactly, but you can take 150 felonies or 400 non-traffic misdemeanors, or the standard says, or some proportion of those two, which I think is, that mixed caseload idea exists everywhere. Jonah also talked about, the traffic misdemeanors, the probation violations, the docket hours. This is kind of a weighted average of what you can take. And so the question kind of became up in a meeting of what exactly, how exactly systems should do that. Oh, well, let's build them a calculator, right? They're tracking their cases, but they're not going to, be offhand, okay, I've done 100 felonies, I've done 25 traffic misdemeanors. How many more of these different cases can I take? And so we thought, oh, well, let's build them a calculator, right? And so that's how it started. We were on a call. I was just kind of typing into Excel while we were talking. I sent it around like, oh, this is really useful. And so the idea was very much, you type in your assignments in the different categories, and it calculates how close you are to the workload maximum, and then how many more cases of those types you can get. And so, this is the first thing we built. It was a very basic, it's just Excel formulas, weighted average type thing. So let's, I'm just going to do this quickly, just to get an idea. Maybe you've got 5 life assignments. You've got 12 high severities, 10 low severities, 50 non-traffics, 20 traffics. Maybe you don't do any probation violations or docket hours. And then it very quickly calculates for you, okay, that is 33% of the annual cap in Michigan for the year. And now if I wanted to take just felonies, how many more could I take? And it's, I can take 101 more felonies based on the work that I've done so far. And so we have really cued in on this percentage of the cap idea. When you've done a certain amount of workload, how much have you done? How much more do you have left? And then you can do it in any number of ways, but these are kind of the maximums you could take in each category. And this is kind of the first thing we started with. And this is, for the full year, because we have our annual, our cap is an annual new assignment workload. It's not an open cases, but it's a full year of work. But it is also does contemplate the fact that the year is a rolling year, and so it's from today for a full year, and then we go a month in the future, and you pick up a new month and you lose another month. It's a 12-month rolling average in the standard, but you can think of it as a 365-day rolling average. You can think of it as a 4-quarter rolling average, those kinds of things. And so we also, in this basic calculator, well, what if you wanted to look at it by quarter, and it just gives you a lower cap, or a month, and again, it just gives you a lower cap. So you can try to think about how close are we to the workload, right? And so like the idea of the calculator, just to avoid having to do the math, is where we started. But then we started thinking about, well, how are the systems actually going to use this? Because as Jonah mentioned, we have a real diversity in terms of the sophistication of the software solutions across our systems. There are some places which have a very good, sophisticated case management system. The only thing that their system doesn't do is build the formula into it, right? But there are some places where they are really just pushing around paper. They get an assignment on their desk, they sign it to somebody, they get the bills in, they approve the bills, they're not tracking anything, right? So there's we thought about how would systems actually start to use this? And so then we built a couple of additional trackers with that in mind. One with the mindset of, what if you had a case management system that had everything but our workload standard formulas? And then it was, well, what if you don't have anything to track caseloads? What would you use? And so we built 2 more of these that use this kind of the same functionality that you're seeing here, but allows you to enter the data in kind of a different format and then run some reports on them. And I'm going to show you both of these, and I put a link in the chat so if you want to look at these, they're all public, they're all on our website. There's documentation and everything associated with this. And so from the first standpoint of, what if you had a case management system and you just didn't have the formulas, and you wanted to monitor your workload, but you wanted to monitor their workload over time with quarters and months falling in and out of the process. And so we basically created what we kind of call the quarterly entry one. Our reporting cadence is very quarterly. All the reports the systems have to submit to us are quarterly reports. And so we said, okay, what if you put your attorney's information in, you put the quarter in, you put their assignments in for a quarter, and you just do that for every attorney for every quarter, and then you can just pull this out and run some reports on it. And we kind of built this into Excel. And I'll talk a little bit about the technical nature of it in a second. But just to give you an idea, so we give them a sheet where they say, type all your attorneys' names in this column right here. Every time you get an attorney, type the new attorney's name in there. We don't want you typing any attorneys' names into the individual data tracking. Everybody's name's got to be spelled the right way and all that kind of stuff. So put the attorney's name on one sheet, and then you enter this data on another sheet. And we built drop-down menus into this. So basically here, you click on the attorney name column and you can select, it's going to take a second to load on Zoom, whatever attorney's names, and all of our systems, they have different, how the formatting of the name doesn't matter, last name, first name, last name, as long as it matches. And then it's a drop-down menu for the quarter. They select the appropriate quarter for the data that they want to put in. And then in these columns for the types of assignments, they type them in. And so you can see here, this is one test attorney in 2 different quarters. I'm going to put, some different data points in here just so you can see it function across the different time periods. And so very basic here. We just type the data in. This is the basic data entry. And then we gave them some reporting templates that look exactly like the calculator that I just showed you originally. So this is if you want to look at 1 quarter. And so you put your attorneys in this column, you select the quarter up here, and then it populates the data without you having to type it in again, and then runs the same calculations we just talked about. So this is test attorney 1. You can see all those 2s I just put in for quarter 2. I'm going to flip the quarter to quarter 1, and it's going to put the 1s in that I had in that spreadsheet. If I pick a different quarter, it's going to drop it all out, right? So it's very much, you type the data into one sheet, and then there's a report generated on another sheet. And so the systems don't have to think about organizing their data very much. It all goes in one spot, and then they report it in a different location. But they care about, annual numbers too. So it's the exact same thing, but now up here, you can select any 4 quarters and it totals it all up. So you can see for our test attorney, here are, the numbers from those 2 quarters I put in added together. It bases the cap on the annual amount as opposed to just the 1 quarterly amount. And again, here, if I drop out this quarter and put in a new one, some of that data falls out. So it's like this, it's very much what you would expect to see in a more sophisticated software product in terms of the reporting functions. It's just all built into Excel. And I'm going to talk about why we did it like that in a second, but I wanted to show you how they work. So again, this is, you have a case management system, you want to put some information in it and follow standard 6. This is how you would do it. But then we thought, well, we're dealing with some systems that don't have case management systems at all. What would you do with those folks who need to monitor the exact same thing? And we thought, well, those folks are going to want to enter the assignments individually. So you pick an attorney from your drop-down menu. You enter the date of the assignment. So we can do today. Description is just whatever you might use in your, the case number or whatever. You select the assignment type based on, our categories that we've already pre-populated. And then it does the work for you. All these grayed out columns are just like variables that we're going to use to pull into the other sheets. So I've given a high severity felony to test attorney 1 assigned today. And then the same concept I just showed you, we have these report generators built in where if you want to see test attorney 1, he or she has no cases in December 2004, but let's go to June 2005 and you'll see it'll pull in that high severity felony. Again, this is for the month. We did the same thing for individual quarters. We did the same thing as select any 4 quarters. And then this one, which just looks at the date and gives you everything from the last 365 days. So we're trying to think about how would they want to look at this data to track the attorney workloads, for our purposes, for their own purposes, to try to make it sort of flexible. And the other, kind of broadly speaking, we very much saw this as this is a bridge, right? This is not how we would want anybody to be tracking this kind of work in the long term, maybe outside of the very smallest systems in the state. We want them to have more mature software with case management systems where this is built in. But as Jonah mentioned, we worked with software vendors to try to get them to build this. And we had more success with some than others, but it was just not very developed. And so we said, well, they need to be able to monitor this stuff now. What can we give them? And so we built these things together. We built these things to give them some options. But what, everybody needed a lot of hand-holding on some of these things. There was requests for customization. We wanted to be as simple as possible, avoid users messing this up. If you developed a software for this, they wouldn't be able to touch the formulas at all. It's all in the back end and everything. But this is just very forward, kind of forward facing to get them through the process between here and a few years from now, because as Jonah kind of alluded to, like the grant is what kind of generates them to start to get compliant and work towards the data collection. And so this is kind of like that in between piece of it. And so they're all trying to use these to monitor things. And the technical aspect of it, I'm happy to talk to anybody about and answer questions, or we can talk. I can put my email in the chat if you want to talk about it. But we were really thinking about how would our systems enter the data, and then how would they want to pull it out of these sheets so that they could both comply with the reporting requirements, but also start to think about how they're monitoring their own attorneys. In this whole system where we have attorneys working across different regions and things as well, which I think Jonah's going to talk about a little bit too going forward. So this is just we can answer questions about these, but this is kind of what we built to solve the problem of there was not standard 6 functions in any one software.
Thanks, Neil. And Bob, I'm seeing your question in the chat. Could we build a transfer from Defender data software or other vendors to our percentage of to our spreadsheets? Maybe, yeah. I mean, I think that that's a possibility. And I also think that, if systems are taking these trackers to these vendors, like Neil said, this is pretty basic math to go into reporting function in software that already exists. So I am hoping that they will be willing to take some of this and build it into their own systems. But if not, then yeah, then maybe that's a possibility. Okay, I'm just gonna share a couple more slides and move kind of quickly so we can take questions. So there's really two major challenges. Can everybody see that? Neil, can you see that? Yeah, Torrin. Okay. There's two major challenges that have really emerged beyond, the use of software. One is how do administrators in decentralized systems know when an attorney who works in multiple systems is nearing or has surpassed their caseload limit? So, let's say Neil takes cases in 3 different district courts in Wayne County, and then also the circuit court in Oakland County. We have attorneys who take cases in up to 12 systems, and they're like mixed and matched all over the place. So how do local administrators know, can Neil get another case or not? It's not only what I've given to Neil, it's also what Neil has gotten from all of these other places. So that is very much today's problem that we're trying to figure out. And then second, which is a problem for another day, is how do we factor in work that's not adult criminal indigent defense work in Michigan? And like I said, that is a year 3 or 4 problem based on what the commission has decided. But today's problem is this, these attorneys who are working in multiple systems. And I think we calculated that there's about 600 of them right now, out of about 1,500 attorneys in the state. And so, we get quarterly data, like I said, that comes in. But that data comes in every 3 months. It does not come in on the day it's due much of the time. It is wrong much of the time. We have to go back to systems back and forth multiple times sometimes to get that data correct. And so by the time that data all gets finalized, let's say by the time Q1 data gets finalized, sometimes it's the beginning of Q3, right? So, I mean, we're about 5 to 6 months behind. So yeah, we get that information and we could give it back to systems and say, this is what we're seeing statewide, but that is not at all in real time. Attorneys could in theory be very far past their caseload limits and nobody would know for 5 or 6 months. And so, so what's the answer? And the answer is we're going to try to build some sort of centralized system where information is coming into us more regularly. And also, in addition to getting case assignments, also collecting data on docket hours or shift coverage hours or whatever people call them in different places. I'm not going to spend a long time on this, but we have started 2 pilot projects in 2 different regions of the state. And we are, trying to use this as a gauge for what is the feasibility of building something centralized. I can answer questions on that if people have, but I wanna just get through. And so, like I said, where we are is a potential RFP to build something like this that would be housed with us. New contract language for all the systems that they would now be required to get us data, not just quarterly on all of these things, but also monthly, specifically just on assignments and docket hours for attorneys. For anybody who's tried to collect information from 120 local funding units, you will know that that is a huge obstacle. I mean, there are so many obstacles in trying to move from quarterly data collection that is already very challenging to monthly data collection. So that's a big hurdle. What do their mechanisms for enforcement look like? Like I said, how we figure out external caseloads down the road, and then eventual reductions in workload maximums that I hope we will see across the state at some point. So I'm going to pause there so we have 10 minutes for questions. I know I flew through the end kind of quickly. But yeah, let me take a break. Let's check the chat, see if there's anything there. Okay. I'm going to stop sharing my screen. Okay, let's see what we have. Okay, Neil, did you answer Michael's question?
No, so if I understand it correctly, the caseload standard sets a maximum for felonies or for misdemeanors, and then it's a proportional balance of those. So it's 150 felonies total you could take, but if you take some misdemeanors, it counts proportionally against the felonies. And so every felony is worth, 2.66 repeating misdemeanors. And so that's how we kind of compare it against. And so on the tracker, it shows what you could take if you only took in that category, because there's kind of no way to just give them a random poll. But so that's how the standard works.
I will say, I think what Michael was getting at, and I only say this because we've been at this slightly longer in Indiana, and we get this question. I think he's asking, like, not all misdemeanors are the same. So,
yes.
Do you take into account, like, the difference between, like, each individual case? I think is the question. No. And Michael,
so
please correct me.
Right. Yeah, if that's the question, no. Traffic misdemeanors and non-traffic misdemeanors are split up in the standard. But no, an individual case, every misdemeanor counts the same, every felony counts the same. Jonah showed, we had the RAND study that does propose that, but that's not how it's being implemented, no.
Yeah, and I do hope at some point that will be broken out differently. And yeah, Bob, DUI is written into the standard as counting differently. I should have put that on the parameters page. Thank you. Melissa, yeah.
Getting at was,
Hi, I think all of this is very interesting, and I wanted to speak. Oh, I'm sorry. Can you hear me?
I'm sorry. I guess so. I'm sorry. Michael was responding, which I didn't realize. Sorry, Michael. Go ahead.
In proportion in the category of felonies, you have different types of crimes, and each type of crime takes a different workload as opposed to the individual cases as a caseload, and takes more time. Some cases take more time, others plead out. Are those factors of each crime, each type of crime, taken into consideration in the formulas?
Yeah, no, the standard does not give space for that. So the idea is really that the concept of things coming out in the wash in terms of averaging, even in the new national numbers that have just come out, it's not paying attention to the individual circumstances of each case. It's really just thinking about it as an average across case types. Right now, like Neil said, we only have this one split. I mean, there's traffic and non-traffic, so I guess it's technically three categories. But eventually we hope to have more. But even once we have more, like the new national numbers that just came out, it's still going to be kind of very broadly across those categories and average. Yeah, Neil, did you want to say something else about that?
Yeah, what I wanted to say is that in my experience, we're talking with systems, we have a really big spread in terms of whether or not the local funding units want us to get more granular or don't want us to get more granular. There's a real disagreement in terms of balancing the administrative burden of tracking cases at a more granular level and the ability to balance the workload at a more granular level. So there's some places that want to really hone in and say, no, I have an attorney who does our murders and I want to give them 15 and we want to account for that, but I want to be able to give, such and such an attorney way more. There are some systems that do not want to track with that level of granularity, and there are some that really want to use that level of granularity. And so right now, we're not at a place where we're implementing, even if the workload, standard could accommodate that without shrinking workloads. There's an administrative burden that we have a lot of pushback on anytime we kind of broach that.
Melissa, did you want to jump in now?
Sure. And everything that you're talking about, I'm Melissa Mackey from the New York State Office of Indigent Legal Services. So a lot of what you were talking about, Jonah and Neil, we've experienced, and we are in a similar situation in that we are a state agency, we receive the data, but it's a county-based system. So we do have over 150 different provider offices, and we're working with them to get the data that we need, and we're required to collect under our enabling legislation. One thing we've done is that we've reached out directly to the vendors. We have a number of county data officers. Those are individuals who are paid through our grant fund, through our funding, through the Harrell Herring settlement, statewide expansion of that. And so we previously had more often, they're tapering off now, but data officer convenings where we would invite all of the vendors for all of the case management systems that we knew were working with those provider offices. And we would go through all of our data reporting requirements so that the vendors themselves would be up to date on what we were looking for. And then we left it up to the provider offices and the vendors to kind of work out what they were going to do. Were they going to change their data entry practices to align with, or were they going to keep their data entry practices and their vendor would have to do the conversion into the way that we needed the information reported to us? Another thing I wanted to speak to, you were asking about, attorneys who are practicing in more than one jurisdiction. We have similar situations where, particularly with our assigned counsel provider offices, our panel attorneys, they work in multiple counties, and we don't have a way of keeping track of how many cases they're being assigned in each of those offices. So one of the things that we're doing new this year, one of our senior research associates worked with our research team and our regional attorneys to create a provider staffing chart. And so for the assigned counsel programs in each county, we're asking them to list their assigned counsel panel attorneys who accepted cases in that past year. And so then we're hoping to be able to do some sort of verification that an attorney is in fact practicing, or what we call maybe self-regionalizing in multiple counties. And there was one other thing, the level of reporting. For our Harrell-Herring counties, for those 5 counties, we get case level information. And so on a quarterly basis, we've been able to more clearly understand and make sure that the cases are being properly categorized as we're looking at their caseload compliance. However, because of various issues and the administrative burden that Neil was speaking of, we don't have case level information from the remaining provider offices. So we get aggregate numbers, and it is a challenge for us to do the data verification. But again, we use the data officers. We have a review process, an internal review process, and we'll kick it back to them, or we'll follow up with them if the numbers over, from year to year seem to really be out of whack comparatively. So, but it is a huge challenge to be a state agency attempting to collect this information from 100, more than 100 different kind of independent providers of indigent defense. But I've been here 9.5 years. We're getting better at it, but it does take a huge amount of work on our end, as I'm sure it is taking on your end.
Thanks, Melissa. Yeah, I've been pretty disappointed in the response of the software vendors. We meet regularly with them. They have all of this information. I mean, I should say at least the 2 or 3 big ones who are in a lot of systems. They have this information. I always say to the local systems, you are the paying client to the software vendor. You need to put the pressure on them, right? I have no purse strings to pull here, so I can beg and beg and beg. But at the end of the day, you need to take this information to them and say, this either needs to get changed or we can't use your product anymore. And I think these systems are overwhelmed. They're working on 1,000 different things. This may not be at the top of that priority list. They don't understand that they do actually have more power than they realize, especially if they come together. I say, look, we have, 40, or probably not 40, but we've got at least 20 systems who use this one product. You all have to come together and approach the vendor. I will be there, right? But as but yeah, I've been disappointed with the response of the vendors who I expected to be, want to change their product and be able to meet the needs of their clients. So with 1 or 2 exceptions. So we'll see where that goes. Thank you for the information.
Yeah.
I'm just finishing responding to Lacey. We're gonna have to switch over to our next presenter. Are there any last questions or comments before we do? All right, Torin, I think we're ready.
All right. Yeah, we can open this up to the next set of presenters.
Hi all, can you see me?
Yes, we see the presentation.
Thank you very much. Hello everyone, it is very nice to be here today, and thank you to IDRA for hosting the concert. At the conference, there might be music later, but hosting the conference. I'm Tatiana Kaplan, Research Data Specialist with the Indigent Defense Improvement Division of the California Office of the State Public Defender. Also joining me today is Keneal Frazier, who is the Executive Director of the Indigent Defense Improvement Division at OSPD. So today I am going to walk all of us through findings from our recent study entitled Unequal Scales, California's Investment Disparity Between Prosecution and Public Defense. Keneal will also share a copy of the report with everyone at the conclusion of the presentation. So just to give a brief overview of what to expect, I am going to begin the presentation today by first providing some background information on California's provision of indigent defense. Then we will look at the current funding landscape for trial court level prosecution and defense in California, beginning with an overview of county level allocations and moving to a review of state-controlled revenue streams in California that support each function. Next, we'll look at state-administered grant programs made available to each function in California and the amounts distributed between 2019 and 2025 in support of those services. I will then present our findings on a small number of grant programs that have demonstrated a more balanced funding model than what we'll see. And we will conclude with a summary of our key findings and then a Q&A. So as you all know, both federal and state constitutions guarantee the right to counsel for indigent individuals facing criminal charges. California has delegated the responsibility of providing indigent defense services for adult criminal trials to its counties. By statute, counties in California are granted the sole authority to decide how to both design and fund their public defense services. So this has essentially resulted in a patchwork of systems across the state, including institutional public defender offices, contract systems, and a few managed assigned counsel systems. Currently, as of today, 24 of California's 58 counties do not have an institutional public defender office. Additionally, there is no centralized structure to support counties in meeting minimum standards for indigent defense, and there is no dedicated state funding nor a comprehensive data collection. So in this way, clearly, when compared to other states, California is somewhat of a national outlier, such that in many states, the responsibility of indigent defense is shared or perhaps even held at the state level, allowing for more consistent funding and more consistent support. So given the provision of public defense in California, the broad purpose of our report was to review the current funding landscape for trial court level prosecution and public defense in California. This included examining allocations for each function at the county level and identifying and reviewing external state-controlled revenue streams, which are state funds or accounts that are collected and distributed by the state, but that can also be used by counties to support local criminal legal system functions. So for example, counties in California have access to funds from Proposition 172, which is a statewide sales tax dedicated to public safety that can be allocated towards public safety departments by counties. We also identified and reviewed state-administered grant programs designed to support either prosecution or public defense-related work. So let's begin first by looking at county-level allocations. So our State Controller's Office, or SCO for short, collects and shares county expenditures for each governmental department, including the district attorney and the public defense system. So we use this data to tally the total expenditures for district attorneys and public defense for fiscal year 2022-23, which is the most recent year that data was available. So as you can see in the graph, counties in California allocated almost $2.2 billion in total funding to local district attorney offices and nearly $1 billion less in funding for public defense. Unfortunately, this disparity is not a one-time occurrence, but part of a long-standing historical trend. So using the same data from the SCO, we can see that between fiscal years 2017 and 2023, the annual disparity in total funding allocations for prosecution and defense ranged between $809 million in fiscal year 2017 on the low end and $940 million in fiscal year 2019 on the high end. The values you see here represent budgetary allocations based on all local, state, and federal resources that are available to counties. And so given the sheer magnitude of this very persistent disparity and the fact that county budgets depend and rely on external support to fund prosecution and defense, it became critical for us to look upstream. Specifically, we looked at state-controlled revenue streams and state-administered grant programs that counties could utilize to bolster funding for each function. So counties in California have access to several state-controlled funds that can be used to support prosecution or public defense. One key factor in understanding the disparities that we just saw in county budgets is the way that these state resources are structured and distributed. We once again turn to the State Controller's Office for this data, which has a dedicated website with tallies for each state-controlled fund. The table you see on the screen shows the amounts available, distributed, or reimbursed to counties under each state control fund that we identified for the most recent year that data was available. Most of it falls under fiscal year 24-25, but a lot of it is for the year prior. So what this means essentially, or what I'm trying to say, is that except for asset forfeiture, the totals that are displayed in the table represent the amounts available within that fund to qualifying offices and not necessarily the amounts actually budgeted or spent by district attorney or public defender offices. The last two columns that you see in the table show whether the monies in that fund or account are or were available to fund prosecution and or public defense. So for example, we can see $109.5 million in the COPS account that was available to counties to fund prosecution, but not public defense work. We can see the same for the asset forfeiture and CalRAP accounts as well. And all three of these have a big X in the public defense column. You will notice a question mark in the very first state control fund listed in the table, and this is for Proposition 172. So Prop 172 was a 1993 ballot initiative which added a half-cent statewide sales tax, often called the public safety sales tax, to fund public safety services. So the enabling language for Prop 172 explicitly lists district attorney offices as eligible for funding, but does not make mention of public defense, which is of course part of public safety. When my colleague and I reviewed county budgets in the very, very early days of this report, we noticed that the Prop 172 account was utilized semi-frequently to fund prosecution in California counties, but less so to fund public defense. And this is an account that provides almost $5 billion in annual funding. So our takeaway, or what we theorized essentially, is that counties may be confused by the ambiguity surrounding Prop 172's enabling language and allowable uses. So between COPS, CalRAP, and the asset forfeiture accounts, that's about $116 million available to fund prosecution work that is not available for defense, and almost $5 billion raised under Prop 172 that appears to primarily support local prosecution and law enforcement, though not necessarily exclusively. The amounts shown in the table represent distributions for 1 year, but over time, the cumulative effect of these allocations just reinforces the imbalances we just saw at the local level. So understanding the structure is essential to understanding how counties can arrive at persistent and large disparities in legal system funding, and why targeted state interventions may be necessary to correct course. So the next step for our research was to identify state-administered grant programs available to fund prosecution or public defense, which is another part of the picture in shaping these county budgets. To identify pertinent grants, we reviewed county budgets and grant-related websites, and we sent out a survey to our wonderful defense community, asking them to identify state-administered grant programs that had funded either prosecution or defense in their county between 2019 and 2025. So once we identified the pertinent grants, we then collected funding amounts from state agency annual reports, requests for proposals, and via public records requests. So in order for a grant program to have been included in our report, the program must have been funded or administered by California, and it must have provided a direct opportunity to support the work of either prosecutors or indigent defense providers at the trial court level. So this includes grant programs using pass-through federal funds, given that the state often has say over such things, such as funding eligibility, priorities, and design. We excluded grant programs that represent direct federal funding opportunities and indirect federal funding opportunities that may result in an ancillary flow, like maybe through partnerships, to prosecutors or public defense providers, or when the principal recipient was a non-criminal legal system entity. We included federally funded victim services grant programs when the primary recipient of the subaward was a county, a district attorney, or a city prosecutor office. These programs are often housed within local DA offices and are functionally tied to the prosecutorial process. On the other hand, we excluded victim service programs when the subawards were primarily issued to nonprofit organizations, as this made it very difficult for us to estimate any portion of funding that may flow to prosecutors. So let's take a look at all the grant programs that we found. So we identified a total of 3 grant programs available in exclusive support of defense-related work between calendar years 2019 and 2025. All of the grant programs you see listed here were funded by the state budget. In total, this represents a state investment of just over $150 million for indigent defense between 2019 and 2025, and all funds for the grant programs you see in the table expire by 2026. We identified a total of 12 state-administered grant programs that were in exclusive support of prosecutorial work between 2019 and 2025. The drug-impaired vertical prosecution program and victim services grants all utilize pass-through funds, while the remaining programs are funded by state dollars. In total, we estimated that $1 billion was available in exclusive support of prosecution work between calendar years 2019 and 25. It is worth noting that for the 3 victim service grants you see, the last 3 listed in the table, there was no annual report available for fiscal year 24-25, and so that sum is not included in the totals you see here. It is also worth noting that many of these programs that support prosecution fund specialized prosecution in areas such as retail theft or insurance fraud, or they endorse a specific model of prosecution, such as vertical prosecution. However, there is no corresponding funding available to indigent defense to address the increased workload generated by these specialized prosecutions. Moreover, to our knowledge, many of the programs in the table that you see have no set expiration. So this chart illustrates the distribution of the aforementioned grant funds by the year in which the grant award was awarded, spanning 2019 through 2025. We can see that there is a very steady flow of funding available for prosecution work, with annual totals consistently across the board exceeding $150 million. In contrast, funding for public defense was quite unstable, and the highest amount awarded was $49.5 million in 2022, which is primarily driven by the Public Defense Pilot Program, which expired in March of this year. The annual gap in funding between prosecution and public defense grant awards ranges from $116 million to $155 million, or $177 million if we actually look at amounts awarded in 2025. This is what the distribution of state-administered grant funding looks like by county when it's expressed as a ratio of funding awarded to prosecution versus defense. So the higher the ratio, the greater the funding gap. Here in this map, there are 32 counties that had ratios between 5 and 10, meaning in each of these counties, prosecution was awarded between 5 to 10 more in state-administered grant funding than public defense. 5 counties had ratios between 10 and 20, and 12 counties in California had ratios of 20 or more, meaning prosecution received 20 times more in state-administered grant funding than did indigent defense. So this is a different way to visualize that data. This is a visualization of the disparities in state-administered grant funding between prosecution and defense in terms of both ratios and absolute dollar amounts. So the bubble size that you see on the screen represents the dollar value of the disparity. How much more in funding in total dollars was awarded to prosecution over defense? And the color intensity of the bubble, which ranges from light green to dark blue, reflects the ratio of grant funding received by prosecution relative to defense. So for example, the darkest blue dot on the map represents a ratio of 317, meaning prosecution in that county received 317 times more in state-administered grant funds than did defense. The smaller bubble size indicates that while the ratio is very large, the absolute dollar difference is less than $20 million. It is worth noting that these relatively small dollar amounts reflect the fact that many of these are small counties with smaller legal systems, which naturally limits the total scale of their budgets and the grant awards that they would receive. Okay, so far we have seen that most state-administered grant funding in California is directed towards prosecution, and that when defense funding is available, it tends to be less consistent and significantly smaller in scale. So Now we're going to take a look at a few state-administered grant programs that produce more equitable funding outcomes. So in addition to state-administered grant programs that exclusively support either prosecution or public defense, we also identified 3 state-administered grant programs that were open to both sides of the legal system. The programs that you see in the table all fund a mix of legal system functions, diversion initiatives, and rehabilitative services. We gathered data for each program from the administering agency's website. So for 2 of the programs, BIRD, JAG, and Proposition 47, we estimated the funding split between prosecution and defense based on the available program descriptions, how the monies were to be used, and any distribution rules. So for example, Proposition 47 requires that at least 50% of each grant award be passed through to community-based organizations. So we estimated how the remaining funds for Prop 47, for example, were divided between prosecution and defense, which are the sums that you see in this table. So based on our estimates, the approximate total funding going to prosecution across the 3 grant programs that we just looked at was $36.5 million and $43.6 million to public defense between 2019 and 2025. So what these programs demonstrate is that more balanced funding distribution is in fact possible when grant programs are open to both sides of the aisle. We don't know really if these programs were designed for more equitable distribution, but collectively they appear to have achieved exactly that. And as we've seen throughout this presentation, most state-administered grant funding in California flows to prosecution, but these programs, while still limited, represent a more balanced investment model based on their design and eligibility criteria. Okay, so let's summarize our key findings and takeaways. So first, we found a persistent $1 billion annual gap between what California counties spend on prosecution versus public defense. This reflects total local expenditure supported by a mix of state and federal and local sources. We also found that state-controlled revenue streams like COPS, CalRAP, and asset forfeiture are available to support prosecution, but not public defense. And Prop 172, which raises nearly $5 billion annually, appears to be underutilized for indigent defense, possibly due to ambiguous statutory language around its intended use. On the state-administered grant side, between 2019 and 2025, we identified 12 prosecution-exclusive grant programs, totaling about $1 billion in awards. In contrast, only 3 defense-exclusive grant programs were identified, totaling $150 million, and all are set to expire by 2026. We also found 3 grant programs structured to support both prosecution and defense, representing a more balanced approach. These programs, the way that they're designed, don't necessarily guarantee equal outcomes or fair outcomes, but their inclusive design makes it more equitable distribution possible. So taken together, the grant landscape and state-controlled revenue streams show a clear pattern. The state invests more in supporting prosecution than defense. And that investment imbalance compounds over time and contributes to the very persistent and large disparities that we see in the county systems. So we believe there is a clear opportunity here when the state designs funding mechanisms to serve both sides of the aisle. The result is a fair and more balanced distribution of public resources. Another option, of course, would be to create corresponding indigent defense funding for any state-administered grant that allocates resources to prosecution. Ultimately, however, to fulfill its constitutional commitment to access to justice, the state must ensure that its own funding structures do not perpetuate local level inequities. And now we can open to questions. I'm going to stop sharing my screen unless you all would like it up if you want to look at a specific slide.
I have a quick question.
Sure.
So I know this is kind of outside of the scope of what you guys looked at, but in very specific areas in Indiana, there are cases where the state pays in for prosecution because of various programs, but our agency, that is also a state agency, requires that the county basically top up that money or stop getting our money, because basically our rule is you have to spend the same on your PDs on what the prosecutors get, regardless of where that money is coming from, very loosely. And in practice, I think it's still significantly unequal. But do you have any information on like if there's a state grant that allows them to hire like 5 new deputy prosecutors, does the county compensate for that in any kind of way on the PD side, or?
I will let Neil jump in, but no, the answer is no.
Okay.
So we don't have any sort of statewide standard or requirement that local counties, right, like you said, top off or sort of equalize funding across the two parties in the adversarial criminal legal system. But that is one. I mean, obviously that would be something that would be wonderful, but also I think Tatiana alluded to this, like assuming we won't get that kind of requirement, right, that the counties have this sort of balance, at minimum, the state, when it is providing a funding stream to the prosecution, should then create a corresponding set of funding that's going to balance, right, the increased prosecution that's going to occur because of the investment. And so it's something we call corresponding funding that we do not see. But that is one of the takeaways of the report, right? Is that if you could create, it's fine if you want to have specialized funding that promotes a certain type of prosecution, but then you need to balance it out and make sure that the corresponding workload that's going to hit defense offices is accounted for and invested in.
There's also a comment, not a question, from Michael Johnson in the chat about wrongful convictions and lawsuit costs. I don't know if either of you wanted to comment on that.
So I will say, yes, I mean, beyond just monetary costs, there's a fairness issue, right? There's a justice issue. There's an issue of how we want our legal systems to work. But absolutely, Michael, there's downstream costs to this, very real economic cost to this disparity in investment. And that's actually an area of research we're currently delving into, looking at how to potentially quantify, how the disparity on the front end, how does that play out on the back end, right? And are you being penny wise and pound foolish by just putting money towards one side when, more equitable investment not only means we're living up to our constitutional mandates, not only we're creating a more fair system, but we're also being more effective with the use of our public funds, right? And not have to pay downstream. And I'll note it's not just wrongful conviction costs and payouts and lawsuits, but it's incarceration costs, right? Both at the local and the state level, as well as societal costs, right? For people who go untreated in terms of mental health or substance abuse issues when we, don't have defenders out there in the system to try to get people interventions that are more appropriate than incarceration.
Thank you for your answer.
Any other questions? We can just open up the floor to kind of general stuff about the session in general, if people would like to talk about it. Can also end early. That is also fine. There was a conversation, a bit more conversation in the chat about private caseload. If anyone has anything they wanted to say about that, in addition to what was said in the chat. Otherwise, we can wait a little bit, see if there's any more questions, and end a little bit early.
And I shared the full report in the chat if anybody wants to download it and see it, and I'll put Tatiana's and my contact information as well.
Thank you, Torin, and the IDRA team for organizing all of this. We appreciate it.
Of course. Thank you guys for agreeing to present. This has been super interesting. I mean, especially to me, because I'm in a similar kind of state level administrator type role, although closer to Michigan than to California. But it's super interesting. I was definitely struck just to see. I mean, California is a very different beast, but I think if you increase the numbers, if we could get to the defense side in Indiana, we would be like overjoyed. But yeah, Andy raised his hand. So go ahead.
Hi folks. I had a question that I've sort of been dying to ask for a while. I'm really interested in the political strategy of using parity as the lever to get more funding, and also wonder how that interacts with caseload standard type advocacy, right? Because as I appreciate it, a caseload standard or a caseload study would say we need funding so that we have enough attorneys to handle caseloads at a certain level. And you can do that analysis without looking at the prosecution at all. You can just say, for every so many misdemeanors we have or whatever, we need an attorney. And that's attractive to me because what it says is the amount of funding that defense needs is based on the work that the defense needs to do. And on the other hand, looking at parity and saying we need as much as the prosecution has is sort of locking you in with whatever they are apparently needing. I wonder if this just, I wonder about the choice of strategy. I wonder if that was a choice. I wonder if there, how you sort of came to this as being the way to look at the funding and resource issue.
I can speak to that a little bit. Well, first I should be clear. So my Office of the State Public Defender, we do not do policy advocacy or legislative advocacy. We do research that hopefully illuminates the state of public defense, and that can be used by advocates to advance, asks, legislative pushes, things like that. But I think to your question, Andy, right? I think as a whole, our office is very skeptical of parity as the sort of like ask. And in creating this report, it was less to say this, the funding decisions should be all driven by parity. It was more to just shine a spotlight on how disparate the investment is at this point in time, and show, it's just a logical matter, obviously. If you funnel so much into one side, what's going to happen on the other side, without explicitly saying, hey, we just need parity. There are other efforts we're engaged in around this workload issue, like you said, and I do think ultimately long-term any strategy or ask for money needs to be tied to the actual work of the defense, because a point we often make, and I think is in other reports and is alluded to in the report we talked about today, is that there's probably more work happening on the defense side, right, on any given case than the prosecution, just given various things, right? The prosecution gets the case already pre-investigated by law enforcement. There's a whole panoply of things that the defense is going to have to do. So long way of saying, I think you're absolutely right to call out that parity alone as the argument is probably not the best way to structure funding asks. But the purpose of our report was to call out the disparity and bring attention to this issue, and then develop potentially more nuanced ways of overall addressing the funding problem for indigent defense in our state.
Neil, did you want to respond to that, or?
Yeah, I just wanted to add, we had kind of an interesting dynamic happening in Michigan because our funding is at the indigent defense level is state funded, and we have this workload standard that kind of cues, and we have a compensation standard. So we have a state line item, budget type situation. And now all the prosecutors have come back and are trying to get massive state grants to match what we got. Now, I don't know what this prosecutor's total budget is statewide because it's all county developed. So we don't have like one line item to compare it. I don't know what the parity is. Question is, but we, I think to answer the question, using the caseload standard as the thing that developed and led to the budget has created a situation where the prosecutors are trying to get money from the state to match what the folks who work under our grants are getting.
Just to, in Indiana, we've had a similar problem because the prosecutors don't have a caseload standard. And I think there's good reasons for that. But just this past legislative session, they tried to kind of create a basically doing the same thing, set up a parity organization to our state level PD organization that would send down some percentage of money, but also require caseload standards. And we were successfully able to argue, although I think in the end it didn't matter, that tying funding to a caseload standard for prosecutors doesn't make sense because they can just file more cases and then they get more money. And so it creates like there's a strategic concern there that is not the case for public defenders because they have to take the cases that are there. They have no control over the inflow of those cases. So yeah, I do think it is a very fraught issue, trying to define parity in a way that's useful without making it something that's also detrimental. We only have a couple more minutes left. Anything else anyone would like to bring up in the remaining couple minutes? All right, I think we can go ahead and end slightly early, give people a slightly longer break. The next session starts at 3:20, so in about 15 minutes. I hope to see you all there. Thank you again to our presenters. This was great. And hope to see you all very soon.